and today we're talking COVID-19 and employment in 2021. Now, like many of you, I certainly hoped we would not still be discussing this topic in 2021, but the good news is at least the questions and the issues we're facing have changed, and I would say for the better. So what are we going to be discussing today? A couple of things. Let's start with the hot topic of the day, which is of course the COVID-19 vaccination. And in there, we'll talk about mandatory vaccinations, the differing issues between unionized and non-unionized workplaces, how you collect and what you should be wary of when you're collecting vaccination information, some thoughts about rapid antigen testing, paid leave entitlements, and then some remaining issues about workplace health and safety. If you have questions during the presentation, please don't hesitate to drop them in the Q&A. I will be monitoring as we go through, though most of them will probably be answered at the end. So let's talk about vaccination. Well, for one thing, I'm really glad we can now talk about vaccination versus a couple months ago. But the question on the tip of everyone's tongue when they call us is generally, Allison, can we mandate that our employees have to get vaccinated? And the answer to that is a very typical lawyer answer, which is technically yes, but practically speaking, having a viable mandatory vaccination policy in your workplace is going to be quite difficult. So practically speaking, it may not be the most practical route of action. So you'd have to consider, first of all, whether or not it is necessary and or appropriate for your particular work environment. So for obvious reasons, that's going to differ between a healthcare setting, let's say, or a setting where most of your workers are office workers working remotely. Particularly outside of the healthcare sphere, workers who are unionized and workplaces that are unionized, you're going to have a particularly difficult time having a mandatory vaccination policy put in place for reasons we're going to discuss. For any vaccination policy, whether mandatory or not mandatory, to reduce your legal risk, you'll want to consider two big things. One, which is proper planning for how you're going to institute this. It shouldn't just be something that you put into place the next day, because there are steps around it that you can take to minimize your legal risk. And secondly, making sure your policy is extremely clear and well drafted will help a great deal. Let's start with those difficulties in the unionized workplace. So interestingly, and it makes sense when you think about it, most of our case law on mandatory vaccinations comes out of the influenza case law. So the flu vaccination or the flu shot's been around for a little while longer. And so a lot of the cases that we have seen in the past are healthcare workers and the influenza shot and whether or not they are mandated to take that. When we talk about any employer policy in a unionized environment, a lawyer is going to refer to the KVP test. And that's just named after the KVP case, which came out of Ontario in 1965, and was a case about what factors will an arbitrator consider when determining whether an employer instituted policy is reasonable and will be upheld. So we know from the influenza case law that when it comes to mandatory vaccination policies, these same factors will be the ones applied. So when you look at the factors, you'll see that in order for your policy, including your vaccination policy, to be upheld, it would have to be consistent with your collective agreement. It would have to be a reasonable exercise of your management rights. It must be clear and unequivocal. It must be brought to the attention of employees. You would have to notify workers that a breach of the policy could result in discharge, and your policy would have to be consistently enforced. So you might look at those and think some of those are fairly easy to meet. And I would agree. In certain workplaces, you probably wouldn't have a problem ensuring that your policy is brought to the attention of all employees, for example. That is not the sticking point when it comes to mandatory vaccination policies and unionized environments. The sticking point is whether or not the policy is reasonable and a reasonable exercise of management rights. So when it comes down to the reasonableness, we know from the influenza case law that there's a couple of factors an arbitrator is going to consider. The first one is if the policy actually aims to protect a vulnerable population that cannot be vaccinated or for which the vaccine is less effective. So we know from the flu vaccine, for example, that it was not available to seniors. So for individual workers in certain care homes, making a mandatory vaccination policy made a lot more sense. That is not generally the case, of course, with COVID-19. At least for seniors, the COVID-19 vaccine is widely used and should be used. So you'd have to consider in your workplace, is there actually a vulnerable population that this policy would help protect? Because that may actually make your policy more likely to be upheld even if it is mandatory. You'd also have to consider, is there a less invasive means of providing protection? So the interesting thing with the COVID-19 pandemic is that for quite a little while, we didn't have a vaccine. And so a lot of workplaces were making do with PPE and social distancing. And the question the arbitrator is going to raise if you try to bring in a mandatory vaccination policy is, well, you operated and you said it was safe enough for 6 months with PPE and social distancing. So why now should I force all of these people to get a vaccination? So again, depending on what your workplace looks like, you're going to want to consider whether or not there is actually a less invasive means of providing protection and build that into your policy regarding vaccination. You'll also want to consider whether a policy is required or recommended by the government. Of course, the prime example of that, for example, is mandatory vaccinations for certain childhood illnesses for childcare workers. Okay, if that is the situation your workplace is in, then of course your policy is more likely to be upheld. Now, as sort of a blanket statement, we can say right now that generally the government has not required or recommended COVID-19 vaccinations for most workplace groups, and therefore take a look at your workplace, take a look at those public health guidelines, but if there is no required or strongly recommended vaccination policy for your industry, again, it's unlikely to be upheld on a mandatory basis. The arbitrator is also going to consider the consequences for non-compliance. So it's the eternal question of what do you do when you put your vaccination policy into place and then someone just says no? Your policy is more likely to be upheld if a violation does not result in discipline or dismissal. And so a lot of you will probably be looking at me right now saying, Allison, if I put in place a vaccination policy, but there's no consequence of not following it, what use is my vaccination policy? I hear that. And what we would normally say is, again, you might have certain groups where more of a mandatory policy is necessary because of the factors we've already discussed, and it might be more likely to be upheld, but you might also be discussing other ways to go about making sure people are safe and healthy than a mandatory vaccination. It might be encouraging vaccination. We usually talk a lot about vaccination education. We talk about incentivizing it, and we'll get into that a little bit more as we go along. Further, your policy is more likely to be upheld, whether it's mandatory or not, if it includes a human rights-based accommodation process. I won't talk about that too much because you'll hear me say human rights-based accommodation about 6 times in the next hour to equal and greater depths. But if you're having a unionized environment and a vaccination policy, include your human rights accommodation piece to make sure your policy is not struck down on that front. And also think about, as I've already mentioned, whether or not you can have less intrusive means of compliance implemented first. And that really is the education and incentivizing piece. Now, that's been a bit about unionized workplaces. What about non-unionized workplaces? Well, if you're non-unionized, you don't have a collective agreement, and you have broader discretion to implement a mandatory vaccination policy for non-union employees. Again, subject to human rights accommodation pieces. But just because you technically can implement a mandatory vaccination policy doesn't mean you aren't going to come up against a couple of very large legal hurdles if you try to do so. There's also a bit of a difference between new employees and existing employees. If you're hiring new employees, we do get asked a lot, can I require them to be vaccinated before I hire them? You possibly can. It's not something we've seen actually go to court yet, so we can't give you a definitive answer until a court does. But right now, it seems like it's possible. You'd have to make sure it's very clearly outlined, however, in your employment agreement and offer letters. And of course, as I said, you're going to hear me say this multiple times, there would have to be some route of accommodation or exemption for applicants who cannot get vaccinated for human rights-based reasons. And to foreshadow human rights-based reasons, I will note it's not just disability, it may include religion and creed as well, okay? So you can't discriminate against applicants who for a human rights-based reason cannot or will not get the vaccine. When we're talking about your existing employees, there's a couple of parts to that. And one of them is that, sure, you put in place your mandatory vaccination policy, and then again, an employee says, no, I don't want to be vaccinated. If you discipline or terminate that employee, there is a decent chance you might have potential liability for contractual or common law termination entitlements. And the reason for that is that there is the possibility that this would be a constructive dismissal, for example, that you're changing the terms under which your employee is employed by you. It's possibly a fundamental or substantial change, and therefore, when you terminate them, you constructively dismiss them, and they have the right to notice and severance pay, or at least they'd sue for it. Now, if you're going to do that type of policy, what we would strongly suggest you speak with your legal counsel about is maybe doing something along the lines of working notice. And again, we're going to talk a little bit more about this, but just in terms of timelines of implementing your policy, you'd want to give people lots of time to comply and notice of what's going to happen if they don't comply. That should help reduce, at least if structured properly, some of that liability for contractual or common law termination entitlements. And as I said, human rights-based complaints, always a concern. If you put in place a mandatory vaccination policy in a non-unionized workforce, you will get people who will refuse, and then after refusal, allege that it was based on a human rights ground for non-compliance. And so you are likely to face some sort of human rights-based or code complaint. You will also face a code complaint, I should note, if your policy is discriminatory in that it doesn't provide some sort of accommodation or exemption for those who can't get vaccinated. Now, all of that sounded fairly doom and gloom, I realize. So let's talk about some of the vaccination policy considerations that you would want to think about for your particular workplace. In terms of benefits to having a vaccination policy, it largely is health and safety related. And of course, that you would minimize business interruption and legal liability. And we're going to talk a little bit about that legal liability if you don't have a vaccination policy and what it looks like and so on and so forth. The risks, human rights code, and of course, there's also the unique risk with a vaccination policy about privacy and confidentiality breaches. If you're asking everyone to get vaccinated and collecting that information, and we'll touch on this again a little while later, is what are you doing with it? And are you ensuring that it is being collected safely? Because that is a risk of a vaccination policy. So we're saying, you might want a vaccination policy or you might be thinking of it because of legal liability. Let's talk about what that legal liability might look like. So sometimes clients come to us and say, we're really worried, what's our liability for workplace transmission of COVID-19? The liability is generally, and again, this is a general statement, relatively low for most businesses for two reasons. For employee claims, the WSIB, if you're registered with the WSIB, has indicated that employees are probably eligible for WSIB coverage for occupational illness, and that will not affect 2020-2021 employer premiums. So if you have workplace transmission of COVID-19 that way, that would be your employee claims, hopefully mostly dealt with as long as you're a WSIB registered employer. If you have non-employee claims, so if claims for people for workplace transmission but the person who was transmitted or infected was not an employee, you would be relying on Bill 218, which is the Supporting Ontario's Recovery and Municipal Elections Act. And this minimizes the risk of liability for claims from non-employees. However, all of this is predicated on the business making good faith efforts to follow public health guidance and any applicable laws related to COVID-19. So Bill 218, just to note, was enacted November 2020, but was retroactive to March 17th, 2020. It does not apply to claims from employees. It does not apply if there was gross negligence, or it does not apply if there were acts or omissions that occurred when your business was required to be closed in whole or in part. So those are understandable exceptions to that, but together this should cover most of the risk for workplace transmission of COVID-19. Though of course, again, depends on a little bit on your business. The next risk you hear us talk a lot about, and as I said, I flagged it several times already, is human rights. So as I've mentioned, mandatory vaccination may be discriminatory unless there's some sort of exemption, and it's probably going to result, if there's no exemption, in a human rights code violation. So 2 grounds, as I flagged already, upon which employees may decline vaccination due to protected grounds is disability is a big one, and then possibly religion or creed. Again, we haven't seen one of these go all the way through yet, so we don't know the 4 corners of it, but it's a possibility. I know that earlier in COVID-19 and vaccination, there was some discussion around sex because pregnant women, but that seems to have mostly died down, and we don't see many people saying that they cannot get vaccinated because of that ground anymore. To minimize your human rights risks, if you're requiring, encouraging, putting in place any type of vaccination policy, you need to make sure it's reasonably necessary as a bona fide occupational requirement. And what that means is, again, just coming back to the idea of, does your workplace really need this person to be vaccinated, or do they not? And that's the difference between, again, sort of a frontline healthcare worker who's working with vulnerable people and somebody like me who works in an office and fairly remotely, usually. My workplace may not be able to prove that's a bona fide occupational requirement that I get vaccinated. You also have to show that you've provided accommodation for an employee who's unable to be vaccinated due to protected ground. And just as a reminder, the threshold for accommodation is that you have to accommodate to the point of undue hardship to the employer. So ways to think about accommodation, and some of the most frequent we end up talking to employers about when there's a potential human rights issue, is just a pure exemption from the policy that certain people do not need to get vaccinated if there's a potential human rights ground, even if we're encouraging and or mandating vaccination. Maybe reassignment to a role where mandatory vaccination is not a bona fide occupational requirement. That is, of course, predicated on their original position really requiring vaccination as a bona fide occupational requirement. You can't just change somebody if it's not a bona fide occupational requirement. And you might also want to think about continued use of PPE to reduce risk. Other areas of liability. People ask us, what happens if I put in place a vaccination policy and maybe it just encourages vaccination, it doesn't mandate them, but the employee is harmed? What do I do about that? And so the WSIB has indicated that if an employee receives a vaccination as part of their employment, and it does actually have to be compulsory at that point, and they have an adverse reaction, coverage may be granted. So an adverse reaction to be covered by the WSIB must be a serious and unexpected reaction. Fever, chills, pain at the injection site, fatigue, headaches for several days, none of that generally constitutes an adverse reaction for the purposes of the WSIB. The federal government has also announced plans for a national vaccination injury compensation program, though we haven't seen any real details around that yet. So again, your liability risk is probably relatively low with regards to employee injury, if there actually is an employee injury from vaccinations that are mandated or required or otherwise encouraged in the workplace. That brings us to one of the other sources of liability that I mentioned earlier, which is just privacy and confidentiality issues. So let's say you go the route of looking at all of this and thinking, maybe I won't put in a vaccination policy that's mandatory, but I'll do a lot of education and encouragement, which is where we see a lot of clients going. You may want to collect information on vaccination status. And so maybe your vaccination policy is education, incentivization, and collection of information. And of course, accommodation. And that's completely fair. As I said, we see a lot of these. So in a unionized environment, as with every policy you'll now know from the KVP test, this is subject to it being reasonably necessary for you to collect vaccination information. And that may actually be something that you're able to prove a little bit stronger than the requirement for a vaccination. You'll also have to, again, consider the consequences for refusal to comply in providing vaccination statuses. As always, discipline may result in potential litigation or liability, although it may be less so than a mandatory vaccination policy. But you also have to consider the privacy implications. So generally, you'll need informed consent in order to collect this information anyway. So you might not have as much of an issue around requirement and so on, because you need people's consent. You also need to ensure you're collecting information that is needed to fulfill your legitimate business objectives. You need to make sure that the information is only used for the purpose collected. And that's important because sometimes, you'll start to see a manager who thinks they'll just check on whether or not somebody's vaccinated. And you have to be very careful about that. You'll have to ensure that information is stored securely to avoid inadvertent disclosures or data breaches. And you'll need to ensure that you safely destroy the information when it's no longer needed. So some of these things you may have already had to deal with in terms of the employee screening that you probably already have in place in terms of collecting that type of health information. But if you're going to collect any type of vaccination information, make sure you're considering how you're collecting and what you're using it for. Okay. Let's talk about some vaccination policy takeaways because I've thrown a lot at you. And so what are the takeaways for you? There is a couple of things. Before implementing your vaccination policy, encourage voluntary compliance, because we've had some workplaces who this becomes basically a mood issue because they have a high rate of compliance. People are getting really involved. There's a lot of peer pressure, which is fantastic for workers to get vaccinated. And hey, they don't even have to worry about a policy and worry about whether or not to require it because it's been dealt with. And that can include education and sometimes incentives. We've had people putting in, the possibility of incentives if you get vaccinated. All sorts of things to consider depending on your workplace. In developing a policy, if you need to do so, look to your local public health guidance, and that includes industry guidance for reasonableness of a mandatory vaccination policy, depending on your type of business, because a lot of you will belong to certain industry groups, and a lot of you will have an eye towards your public health units as well. And you'll want to see what they're publishing in terms of should vaccination be pushed? Is there an industry consensus on whether or not it's necessary? Consider all the benefits and risks. Sometimes we get a lot of, we want a mandatory vaccination policy, and that's completely fair, but let's talk about the risks and benefits for your specific workplace before you decide sort of either way. If there's a theme for this section, it's please address disability and religious accommodation in any policy. If you leave it out, you're just asking for trouble at that point in time. Also, maybe what you want to do is you want to be encouraging and educating and talking about alternative options if an employee does not want to be vaccinated. Maybe you're going to keep that employee working from home. Maybe they're going to be on a leave of absence. Maybe you'll be talking about continued use of PPE. These are all things that you can talk about. And again, depending on how your workplace is situated, you might be dealing with this on a person-by-person basis, but this is important to think about. Are there alternatives to requiring vaccination? Then, of course, determine what information you actually need and how it's going to be safely collected. And as I've mentioned, provide as much advance notice as possible to reduce the risks of further claims. If you actually have a union, maybe engage with the union. Some unions have been very open to actually talking about vaccination policies or vaccination encouragement or what have you. Make sure employees understand the purpose of the policy, enforce it consistently, but allow for accommodation. And again, if you have specific legal counsel and you've got specific questions about how it fits in your workplace, talk to your legal counsel about it. Now, I know we've got a couple of questions about vaccination. I'm going to keep going just to make sure we stay on time and then come back around to questions, but please don't hesitate to keep throwing them in the Q&A so I can make sure I don't miss or forget anything. Let's talk briefly about screening for COVID-19, because this often goes hand in hand with the vaccination policy issue. What is rapid testing? So a lot of you might be familiar with the fact that rapid antigen testing is sort of the other big area of discussion these days. Initially, it was a pilot program in Ontario. As of May 7th, 2021, the government program expanded to provide free testing to small and medium-sized businesses. So you can actually get rapid antigen testing kits on your own. But if you want to participate in the government program, it's now open to more businesses than it used to. Rapid antigen testing detects antigens, which are the viral proteins in the biological sample. It's different than the PCR test and therefore cannot be used for the same types of situations. There are very different situations when you'd use the two. As the name implies, it's quite rapid. You'll get the results within 15 minutes. Now, rapid antigen testing can be used to complement that employee screening you're doing every day when your employees come into the workplace, but cannot be used to replace all your other public health measures. To participate in the government program, you need to agree to the program terms of the Government of Ontario. You need to provide the location and staff to implement testing. You order your free kits from the Government of Ontario, and then you report your program data to the ministry as required. If you go online and you look at the rapid antigen testing program with the government, you'll see a lot of the details there about exactly how it works and what you have to respond, but those are the basic steps. Now, when can you use rapid testing? You use it for asymptomatic individuals who have already passed that entry screening. So you know that screening you're doing that asks, do you have any weird muscle aches? Do you have a sniffly nose that's not for any other reason? Have you been outside the province? That sort of thing. That's the entry-level screening. Once an employee passes that, you can use rapid testing. And yes, you can use rapid testing for those who've already been vaccinated. Rapid testing, however, cannot be used unless public health explicitly tells you otherwise if an outbreak is declared or you suspect there's an outbreak for symptomatic individuals. So somebody who failed that screening and says, yes, I do have a runny nose, you cannot use rapid antigen testing on, nor can you use it for an individual who's already infected or was infected and has just recovered. So in those situations, you need to be using PCR testing or requiring PCR testing, not rapid antigen testing. So let's say you decide, you've thought about vaccination, you might not want to put in a mandatory vaccination policy. You're going to do a lot of encouragement, but to keep your workplace safe and healthy, you're also thinking about rapid antigen testing. What happens when the employee refuses and there's basically a lawsuit or a grievance about it? Now, generally, refusal to participate in rapid testing may result in discipline as long as that's in your policy. We don't have case law on this in the non-unionized sector yet. We've only seen it in the unionized sector, and therefore that's a lot of what we have to look at in terms of the arbitrators looking at these policies. Of course, you'll know the theme already. The arbitrator is going to look at whether or not it's a reasonable policy. There's a little bit more hope here than there was in vaccination policies for unionized employers. Because in 2020, in the Carison Care case you see on the screen, an arbitrator did find that the PCR testing requirement at the time was reasonable in a retirement home. So that was a policy grievance over biweekly COVID testing on all staff. There hadn't been any positive tests at that point in time, but the arbitrator looked at this and said, an employer shouldn't have to wait until there's an outbreak in order to take proactive steps. And it was fine that if somebody refused, they would be held out of service until they complied. So the test was implemented, it was mandatory, it was upheld by an arbitrator. That, of course, was in 2020. That, of course, was in a care home. And that, of course, was before there was vaccine approval. Now, there is a more recent case that we've just seen in the last week or so come out about Elliston Construction implementing an antigen testing program that the union grieved, and arbitrator Kitchen at the time upheld it as being reasonable. Again, that didn't really address vaccination. At what point in time does a rapid antigen test requirement become unreasonable because so many of your employees are vaccinated? Okay, so it's going to be a little bit of a weighing between the two and seeing how much uptake or how successful all of your education and incentivizing really is. We suspect, although we haven't seen it yet, that vaccination status may influence the relative utility of antigen testing in a workplace. So it might be something you want to consider. Again, depends on your workplace. And you'll also have to consider what type of work does your workers do, right? And we've talked about this with the vaccination. Does it really make sense to be rapid antigen testing your workers in the particular circumstances of your work environment? Because it requires a higher testing frequency than PCR testing, be aware that workers are also going to see it as more invasive. And that is something we might have to deal with in a court eventually if someone sues over a rapid antigen testing requirement in a non-unionized environment. This brings me around to our third topic, which is paid leave entitlements. And this is a big topic, I know, because there was the change as of April 29th, 2021 to Bill 284, which introduced paid infectious disease emergency leave. So as many of you, I'm sure, are more than aware, infectious disease emergency leave is not new. We've been dealing with it for months at this point in time, and employees have been entitled to unpaid leave for certain COVID-related reasons for those months. The difference with Bill 284 is that employees now have entitlements to 3 paid days of leave. One of the interesting things with this, as I've flagged here, because it goes with the theme of the rest of our presentation, is that paid leave can be used for vaccination, for example, or any ill effects felt by vaccination. So if you're really trying to do not a mandatory vaccination policy, but a strongly encouraged vaccination policy, you may want to remind employees that, of course, they're entitled to possibly entitled to paid leave. We're going to discuss that for vaccination and to recover from associated side effects. So employees are entitled to 3 paid idle days between April 19th, 2021 and September 25th, 2021, subject to the calculations we're going to go through in a minute. I get asked every time I say that, is April 19th, 2021 a typo? Allison, you said this came into force April 29th. It's actually applicable retroactively for the 10 days before it came into force. The 3 paid idle days do not need to be taken consecutively. So somebody could take one day and then take another day 3 weeks later and then take the last day, September 24th, 2021. It's important to note that although paid idle can be used for vaccination, that is not the only thing it can be used for. An employee can access paid idle for the same reasons they would have used unpaid idle. So that includes that the employee is under individual medical investigation, supervision, or treatment related to COVID-19. So previously that had to be unpaid leave. Now they can get 3 days of that paid. If the employee is acting in accordance with orders from the Health Promotion and Protection and Promotion Act that relate to COVID-19. If the employee is in quarantine or isolation or under a control measure due to COVID-19, they can also access the paid idle. If the employee is under your direction as the employer to not attend at work in relation to a concern that they might have been exposed or might have exposed others to COVID-19, that can also be come under paid idle. They can also access paid idle days if the employee is providing care and support to a prescribed family member because the family member is under individual medical investigation, supervision, or treatment related to COVID, or is in quarantine, or for any other reason, the same reasons that would entitle the employee to idle. So that's quite an expansive provision. And I just want to make you aware that when we talk about family members, prescribed family members for the reasons of accessing idle or paid idle, it includes not only the spouse, it can include parents, step-parents, children, brothers, stepbrothers, grandparents, brothers-in-law, sons-in-laws, uncles, nephews, so on and so forth. There's actually quite a list and it is quite expansive. So that means that if somebody is home because they might have exposed others to COVID-19 or they've been directed by their employer to stay at home and it happens to be somebody that the employee needs to take care of, your employee may be able to access paid idle for that. So how do paid idle and unpaid idle work together is a question we get a lot. So if paid idle is exhausted, generally the employee may take unpaid. The default for the employer is that you should always try to ensure that the paid leave is exhausted before you go to unpaid entitlements. However, and this is an interesting twist that a couple of clients have seen recently, your employee may elect to take an unpaid day first and try to save their paid days for later use. And they can do so. They just have to advise you in writing before the end of the pay period in which the leave was taken. How do you apply paid idle and what does it really look like? So the per day payment is the lesser of the employee's regular wages, or $200. The tricky one is the second statement on this slide, which is that paid idle does not apply if employer has a policy already providing this benefit. So April 19th, 2021 is the magic day. This is the day upon which you calculate what paid idle entitlements every single employee of yours might have. So let's say you're doing this current day. Somebody has to take paid idle. To determine what their paid idle entitlements are, you got to look back to April 19th, 2021. You ask, as of April 19th, 2021, were there paid sick or personal days or any paid days of any sort that your company offered that could be used for any reason that would be covered by the paid idle leave? So note, it doesn't just have to be paid sick days because the paid and unpaid idle covers a lot more than just paid sick days. So sometimes employers will just have paid flex days where you can just take 3 extra paid days off, or personal days. Those would count for this. So you look at April 19th, 2021, you determine whether your company had any sort of that entitlement as of that date. And if so, any employee who has used up their company paid personal sick days, whatever it might be, as of April 19th, 2021, is entitled to up to 3 idle days. For any employee who still has some of their company, I'm just going to call them paid personal days remaining as of April 19th, then their number of available sick days or paid personal days as of April 19th reduce the number of paid idle days they're entitled to. This sounds very tricky, so let's do an example. April 19th, 2021, employee Bob was entitled to 3 paid personal days under your policy, and they could be used for the same reasons as paid idle days. But as of April 19th, 2021, he only has 1 day remaining out of his 3 days that you gave him. So employee Bob gets 2 paid idle days because he had 1 paid personal day from you already as of April 19th remaining, and he gets 2 more idle days to top him up to the 3 days. However, employee Carol has 2 days of the personal days remaining as of April 19th. she only gets 1 paid idle day because that brings her up to the 3. And employee Chris, who, didn't have to use any of his paid personal days and still has 3 remaining as of April 19th, doesn't get any paid idle days. We fully recognize this seems blatantly unfair sometimes when we talk about it to employers, but that is the way it does go, and that's the scheme currently. Now, an employer can apply to the WCIB for repayment of paid idle, but if somebody's idle days were reduced because they had paid personal days of some kind from you, you can't ask for reimbursement of those paid personal days. Also, remember that you have to apply to the WCB within 120 days of the sick day being taken in order for you to get reimbursed. Let's move along just to our last topic, which is workplace health and safety requirements on top of what we've already discussed. Because it is a very frequent question, yes, while vaccination is ongoing, let's say you have 100% vaccination in your workplace, which would be impressive, it doesn't matter. You must still continue to comply with the Reopening Ontario Act and the changes to the Ontario framework that we saw the Doug Ford government bring in on May 20th, 2021. You also must continue to comply with the advice, recommendations, instruction, and orders from public health. And as you will all know, probably all too well, those were earlier in the pandemic and generally included instructions around physical distancing, PPE, active screening, outbreak reporting, contact tracing, and wearing of masks. Municipal bylaws also govern your business operations, and that can include COVID-19 obligations. They do differ from region to region, but while vaccination is ongoing, all of these are still in effect and must be complied with. Because some employers are just now bringing people back to work and may have not had a safety plan in place before, please remember you must have a COVID-19 workplace safety plan. It must be in writing. It must be posted somewhere very conspicuous, and you have to be available, have it available if any person requests it. This is your written roadmap on how your business will address COVID-19 transmission risks. And that generally includes education about COVID, screening, physical distancing, masks, disinfecting, wearing of PPE, all of that sort of thing. Although the obligation for a safety plan comes from the Reopening Ontario Act, the rationale is really related to the Occupational Health and Safety Act, because you have the obligation to take any and every precaution reasonable to keep your workers safe and healthy. You are encouraged to keep this safety plan updated. You do not have to send it to the MLSTD, which is the Ministry of Labor, but you need to have it on hand because, and we'll get to this sort of as one of our very last slides, if you get audited or visited by an inspector, you have to be able to pull out your safety plan. And so it's kind of, it might seem like a pain, but not having one, believe me, will be more of a pain. If you're interested, there are a couple of questions that the MLSTD specifically suggests you think about with your safety plan. And that's generally the things we've already talked about, right? How will you screen? How will you control risk of termination, transmission? Are there any new risks because of COVID-19 in your workplace? So as you're bringing back workers, you might be using new chemicals. Are there any risks associated with it? It has to be addressed in your safety plan. Do you have heavy lifting that previously people would just do? Does COVID contain any risks for that? Got to include it in your safety plan. You have to maintain your on-site screening. So this is the active screening that anyone who's had workers in the last little while on their workplace has been doing. Please remember to double check the government mandated screening questions every once in a while because they do periodically update. Remember, you have to maintain your screening records for 30 days. So again, you have to keep screening even though vaccination is now coming in, and you have to maintain those records. You may also have to screen your customers, so make sure you are following your local public health guidelines on that because it does change region by region. And I will say, even within regions, there is some variation. Let's say you are now getting a positive case. I really hope this does not happen to anyone, but surprisingly, we're now seeing employers coming to us with their first positive case because with vaccination, and people returning, sometimes it's happening for the first time now. A couple of things. First of all, communicate with your positive employee, request the written confirmation of the test result, confirm the duration of the quarantine period with them, arrange for their leave of absence, obtain all the information you would need to do contact tracing. So when were they last in? Who did they talk to? What were they doing? Follow up during the isolation period to determine their status and when they might be permitted to return to the workplace. And then the second issue is comply with public health requirements. That's the big one. So whatever public health tells you to do, you should be doing. And you'll want to have communicated with your positive employee beforehand so you have all the information public health will need. Now, public health will generally only contact the employer if it appears the employee was infectious when they were last at work, and any other workers should be notified or tested. So if you don't hear from public health, that is actually okay. That's not a problem. If you have to notify other employees, so employee Bob was infectious and talked to 4 other employees, yes, you do have to notify them. You have to do your best to maintain the privacy of who the positive individual is. You have to confirm that you're working with public health to advise any close contacts if that is an issue, and you should be highlighting the existing and additional precautions that will be taken. The fifth one is the other big one, which is that you have to comply with any and all MLSTD reporting requirements. Generally, you have to report an occupational illness within 4 days if you are advised by the worker that the worker has an occupational illness or a WCB claim has been filed for an occupational illness. And so note that occupational illness generally means coming from the workplace. So if the worker says, I got COVID from Bob last week, that might very well be a claim of occupational illness. If you are not sure about whether or not to report to the MLSTD, please, please, please check with your legal advisors. That is not something you want to be just leaving out there. And also, you don't quite frankly want to be reporting it if you don't have to. You may also have to provide notice to a joint health and safety committee and your union, if any. And definitely, as I said, seek legal advice. The regional class orders change fairly frequently about what type of contact tracing, if any, you have to do and who you have to report it to. So it is an ongoing and a bit of a moving target, but those are the 5 main considerations. Couple of reminders for our last slide on the presentation, and we are in good time to answer some questions afterwards. Please remind everyone, remind your workers, remind your managers, remind your supervisors that vaccination status is not currently an exemption from compliance with public health and safety requirements. So people, we get this a lot, will say, well, my employee is willing to provide proof that they've got both vaccination jabs and they don't want to wear a mask. Too bad, they've got to wear a mask, okay, if that's required for your workplace, or otherwise abide by the social distancing PPE protocols that you have in place. Antigen testing is not an exemption from screening requirements. So as I said, it seems maybe a little bit stupid that you have to do the active screening and then antigen testing, but that is the way to go. Because remember, if someone failed the initial screen, you can't antigen test them. They have to go get the PCR test. And please be prepared for workplace inspection. We get a lot of calls from people who say, Ministry of Labor, Ministry of Health, Public Health was just in. And there's a couple of easy things, as I've already mentioned, that you can do just to make sure that you're not getting dinged for something relatively minor. Make sure you have your safety plan and that you've complied with COVID requirements, again, despite vaccination status and antigen testing. And we bring this because they've hired 100 new OSHA inspectors since the start of the pandemic. And the MLSTD is actively inspecting workplaces. We can tell you this from seeing it with our clients. Since January 2021, there's been more than 13,000 inspections. That resulted in 9,500 orders and 375 tickets. Public health and municipal enforcement officials are also generally inspecting. Penalties can be quite steep these days. At the beginning of the pandemic, they were mostly focusing on education. We've gone a little bit from carrot to stick at this point in time, and the penalties can be quite hefty. A provincial offenses ticket of $750 might be the first step, but failure to comply can come with generally quite large fines. So just for everyone's peace of mind, there's a couple of things you want to abide by, and these would be them. Okay, so that brings me to the end of the planned topics for today's discussion, and I know we have some questions. So let's take a look at them. Okay, so one of the anonymous attendees asked, are we doing contact tracing as the employer? Wouldn't public health notify other employees? You're not wrong, but here's what happens generally if you have an individual who is tested positive. The individual will call you and say, I've tested positive. What should I do? And what I'm saying is that in that original call, you as the employer, in order to prevent an outbreak from expanding in your workplace, will want to know what was the last shift you were in? Who did you talk to? Because you want to send those people home as soon as possible. So we use contact tracing sort of in two different ways. You're right, public health does a lot of the formal contact tracing, but especially not so much right now, but especially at the height of the pandemic, they weren't able to keep up. And so if you waited for public health to tell you who you should send home or send to go get a COVID test, you could find yourself in a situation where in the interim, somebody's infected 4 or 5 other people potentially. And so in order to keep a lid on it, I'm using contact tracing in sort of the loosest sense of just in your workplace, figure out who they talked to, who they were on shift with, who they might have been close to, and send those people to go get tested or to isolate in order to make sure that you stamp down hard on the possibility of it expanding and getting worse. Okay. Let's look at, so what would appropriate disability religious reasons for not wanting to be vaccinated look like? Yeah, it's an ongoing question and one we're sort of seeing new heights coming out of. And the reason why there isn't an explicit list is because, as we all know from dealing with human rights, there's always a new human rights ground. And I put that as kindly as possible. Somebody might very well come and say, I have this condition and it doesn't allow me to be vaccinated. You ask about a doctor's note for the former be reasonable, quite reasonable, okay? If you're requiring or discussing vaccination and somebody says, I have A, B, C, D and can't get vaccinated, it's quite reasonable to ask about medical notes for that. Now, you might already know somebody has a certain condition and now they're telling you they're unable to get vaccinated. You might just ask them, do you mind just getting your doctor to send me a note saying that because of your condition, you can't get vaccinated? Again, that depends how much you're mandating vaccination and how much information you're collecting. But yes, if somebody's looking for an accommodation, you have every right to ask about medical documentation. I will note here that sometimes you can't actually ask for a diagnosis per se. Somebody's doctor might write and say, so-and-so cannot get vaccinated for health reasons. Unfortunately, you might have to accommodate that individual, even though it doesn't say for this reason, the individual cannot get health reason